YouTube in progress. There we go. Good morning and welcome to the First District Court of Appeals. We have several cases on our docket this morning to be argued. The first of those is State versus Mcbride. Mr. Thompson is here on behalf of appellant. Ms. Steer is here on behalf of appellee. Mr. Thompson, would you like to reserve any time this morning of your 15 minutes?
Yes, Your Honor, 3 minutes, please.
All right. And whenever you're ready, you may begin. And before you begin, I know you both received our order requesting that you address whether or not this case should be stayed in light of the case in front of the Supreme Court, Nicholas. So, Mr. Thompson, you may begin and you can use any of your time as you choose.
Thank you, Your Honor. May it please the court, counsel. Well, when I looked at whether this court should wait for the Supreme Court to decide this case, I really saw three options. The first is that this court could decide the case and rule in our favor. If that happened, David would be sent back to juvenile court for a new amenability hearing that uses a clear and convincing standard. If the Supreme Court agrees with that, great. We were all very efficient. If the Supreme Court disagrees, the new amenability hearing will have been a nullity and David will go back to adult prison, assuming he wasn't sent there after the new amenability hearing. But he would also receive the benefit of spending another year of his youth in a juvenile facility rather than an adult facility. This potentially uses up more resources, as we would obviously appeal if David was bound back over to adult court using that clear and convincing standard.
But wouldn't the state just appeal? I mean, if we would rule in your favor, they would appeal it, and then the Supreme Court would probably combine it or stay it.
Correct.
Decision, right? So it gets stayed either way.
That ultimately was the second option I considered, and that if the case was decided and you ruled against us, then that maintains the status quo. I think we could assume the Supreme Court would accept the case and hold it for ruling. It would require a little bit of resources to send the case to the Supreme Court. The third option is that this court holds the case until the Supreme Court decides. That certainly maintains the status quo as well and preserves everybody's resources. But while holding the case is the least resource intensive option, I was thinking about it and weighing those. The more time that passes, the easier it becomes for the state to argue that David is not amenable to treatment in juvenile court because he just keeps getting closer and closer to 21 years old. So we argue it's worth the risk.
I'm sorry, what is his age right now?
He was 15 in 2018, so he's probably 18 or 19 right in there. I don't have his birth date in front of me.
He's probably not receiving any treatment at the moment, right?
I'm not aware. The state certainly argued there was treatment in adult court or in adult prisons, but he's definitely not getting any sort of juvenile treatment.
If it were sent back for an amenability hearing, would the court look at his amenability at the time, or would it fast forward to present day?
We would certainly argue that you should look at it at the time. I think that's a difficult question because obviously the question that remains is, can we treat you in the next 3 or 4 years? And I could certainly see an argument that it should be the time of the hearing.
Thank you.
Well, let me ask you this. Like, as I look at the case law that's existing today, especially from our district, it is a kind of nebulous balancing test that we reviewed for abuse of discretion. And I certainly understand your argument that this is not a sufficiently clear standard and that there should be kind of more teeth to it. But it seems to me like what the argument is in the Supreme Court case is to actually implement a new standard that is more or less at odds with the existing standard that prevails right now. So I guess my question is, how could we rule for you now in line with that precedent?
Well, I think ultimately that boils down to that word outweigh in the statute 2152-12. We would argue that that's, and I think ultimately the Donovan side of things argues that's not a standard. You could see how it could be viewed as essentially a preponderance standard, but that word outweigh, I'm not aware of it being used really anywhere else. It's not a standard that is typically laid out as a standard of review in a case. You get something like preponderance or beyond a reasonable doubt or clear and convincing. And I think that's kind of the problem that we run into, and why it's raised as a procedural due process issue, is that you really don't know what you're getting into, and it kind of depends on how each individual juvenile judge views that outweigh standard. It's amorphous and changing, and really both sides are struggle to interact with a standard that you really don't know how much evidence has to be put on.
Well, no, and I get that, and I mean that's why maybe that's why the Supreme Court took the case to clarify that or to refine it, but the law as it stands is imperfect though it may be, is that there is some balancing that's kind of vested in the trial court's discretion, and so I'm just struggling with what we do with that vis-a-vis the Supreme Court.
I think also it's obviously the easiest thing to do to hold on to it and just wait and see what happens. But that benefits David the least. In considering this is a juvenile case and how young he was, and ultimately the argument we make in our second assignment of error that he shouldn't have been transferred to adult court, it really doesn't do the state or anyone any harm to give David a chance to use the new standard. If it turns out we're completely wrong, he's still going to be held. This will all be done before he has any chance of being released. If it turns out we're wrong, he just goes back and does his 18 years. So I think it's a low risk scenario to go ahead and decide the case and hold that there is a due process violation to have a hearing without any real standard. I know that it would get this weird sort of abuse of discretion review, which is an incredibly difficult hurdle to overcome when we don't get a clear view of how we are supposed to weigh these factors in the beginning.
May I ask, I want to go back to something you said, and that is, if we would find in your client's favor, perhaps saying that there is this standard of clear and convincing, or for whatever reason, and we sent it back and there was a new amenability hearing and your client was kept in juvenile court, and then the Supreme Court decided Nicholas and said, no, it's not a clear and convincing standard. Why necessarily would our prior decision be a nullity? Wouldn't there have had to have been an appeal to the Supreme Court? The Supreme Court agrees to take it and then reversed it. Otherwise, wouldn't our order stand?
I suppose the state might have to file something, whether it be an expedited or an accelerated appeal or something like that, but it would I imagine this court would act very quickly on that. That clearly that needed to be overruled if the Supreme Court doesn't go Donovan's way.
You argue in your brief that even under an abuse of discretion standard, you win. And I'm trying to understand how so. It seems to me that the judge very carefully laid out why he was rejecting the experts' testimony, and so I guess I question how you would make an argument that he arbitrarily ignored the experts in this case, because you seem to really consider their reports and what they had to say.
The one thing that the trial court found that really stood out to me was that it found that David showed no signs of a serious mental illness. I don't know how it could hear two experts that's what they do for a living, that decide if people have mental health problems. Judges are experts in the law, not mental health, and David had a number of diagnoses: adolescent conduct disorder, recurrent major depressive disorder, anxiety disorder, exhibitionistic disorder, and unspecified paraphilic disorder. To find that he had no signs of major or no serious mental illness, it doesn't make any sense. I mean, in a way,
didn't the judge note that I think the experts in their reports were claiming that your client was, I guess, malingering in some respects or exaggerating, faking?
That did come up. They used the word highlighting, that he was trying to shine more of a light on his faults than the positives in his life. I don't think that either one of them suggested he was malingering, which it doesn't seem that he had the capacity to try to pretend to be mentally ill in order to get out of trouble. In a weird way, it doesn't make there's no argument that he didn't do these things. To say he didn't have any sort of serious mental illness would somehow suggest that this is a normal thing to do. And it doesn't make any sense. And it doesn't also comport with any idea that he was engaging in any sort of planning. This seemed like a very opportunistic set of acts on his part. He just sort of went and kept doing the same thing. And frankly, if it was a plan, it was a terrible plan to keep going to the same place and doing the same thing and keep almost getting caught and then eventually getting caught. So the factors.
Mr. Thompson, you are at your time if you'd like to reserve 3 minutes.
I'd like to reserve the remainder. Thank you, Your Honor.
All right, thank you. Ms. Steer?
Morning, Your Honor. Counsel, may it please the court. I'll start with whether or not this should be stayed for decision in the Nicholas case up at the Supreme Court. I would argue that it shouldn't be stayed. First, because as I point out in my brief, they didn't preserve this issue, whether or not the constitutionality of 2152-12. The arguments that counsel made during the amenability hearing were with respect to the specific factors, and that they kind of included an essence of guilt. And that's what the argument I believe she was making down below. At no point was there like a due process challenge to the actual weighing that happened. So it hasn't been preserved. And secondly, I think even if this court were to adopt the clear and convincing standard, I think that the result would be the same. If you read the end of the judge's decision, what he attached to the back of the factors, he said that overwhelming evidence has been presented that clearly indicates that the juvenile court cannot properly rehabilitate the defendant at this time. To me, that sounds like clear and convincing evidence. And I think when you look at his decision and you step through, you'll find that most of the stuff he found was clear and convincing. So I think under.
Well, can we just, I mean, that's an interesting argument, but can we just assume that he would have found clear and convincing evidence when he did not, when that was not the standard that he was applying?
Well, I'm just going on that, Judge, but I don't know that we can assume it, but it seems to me that based on what he says in his decision, it was pretty overwhelming evidence. I think the fact that he said overwhelming evidence, to me, that sounds like more than a preponderance. And I think we take him at his word, what he wrote in his decision. So I would argue that we should just move forward with this case and not hold it. There's a risk, I think, of holding it because at this time he is 18 and a half. His birthday was in February. By the time the Supreme Court decides the case, they're hearing argument on December 7th. Even if at the best they get it out in 3 months, because I know they do try to expedite juvenile cases, he'll be 19 years old. Judge Myers, you asked what happens as far as considering amenability. If it were to be sent back, do they consider his amenability at the time of the offense or at the current time? I tried to look for cases where cases were reversed on amenability and what happens when they go back, and I was unable to find anything. The only indication I can find is, and this is pretty tangential, there's a Supreme Court case, In re DH 152 Ohio State 3rd 310, and that was a question about whether or not a decision to bind over was a final order. And in that case, the Supreme Court said that the fact that time is running against the juvenile and that they're losing time to be rehabilitated does not give them an inadequate remedy at law. To me, that kind of indicates that they would pick it up. You would pick it up at wherever at the time when it's sent back. So in this case, at best, I would guess we'd be looking at whether he's amenable at the age of 19. And when you look at that, even the expert, I think Dr. Lysing, I probably butchered her name, she said they needed 5.5. She thought 5.5 years would be adequate to get him.
Well, and so that kind of circles back to Mr. Thompson's point about efficiency. And I know that that's not necessarily what should guide our decision, but he's saying the longer this gets dragged out, the harder it's going to be for him to make an amenability showing, especially if you're right. And so wouldn't the most efficient outcome be we should send it back for the hearing under clear convincing, and then that's all done by the time the Supreme Court decides, then we'll know either way, and either we were wrong in doing that or we were right. But if we were right, then he's kind of gotten that much of a head start on treatment of the juvenile system.
Well, Judge, I'll be honest with you. If you guys decide that it's going back for an amenability hearing on clear and convincing, the state will appeal it. And then we have at least, probably 3 months from our appeal when the court even decides whether or not to take jurisdiction. So even if the court weren't to accept our jurisdiction, I would suspect that they would likely hold it. But even if they were not to take jurisdiction, we're probably still to February or March. He's still 19 and we're in the same situation. I'm not sure that we save a whole lot of time either way. I mean,
wouldn't any decision that if we ruled in the defendant's favor in any way, the state would appeal, correct?
Correct.
So there would.
I'm assuming so. I don't get to make that decision, but
I understand. So I mean, it just seems like there's not going to be another amenability hearing anytime in the near future if we ruled in his favor.
Right. It seemed. I mean, I think, and I think that's when I was looking at this, I can't find anything, and I think part of it is because. And it probably spills over to the argument against a clear and convincing, we trust the juvenile court. That's why they get such broad discretion in deciding these. And I think that maybe that's why this isn't set up so great for what happens on appeal. I mean, even no matter how much you expedite it, you know, and David was 15, he was like nearly 16 by the time the court decided. And I think it was moving along. I don't think anyone thinks that this was dragging out, but you know, you have a lot of other juveniles who are even older when they commit their crimes. And I just don't know.
Yeah, and I guess that's my underlying concern. I mean, just from a macro perspective, and I have this same concern in the parental termination cases, is that, you know, these cases drag on so long, and then, you know, then the state's arguing like, well, we've been in this situation, like we can't depart from it now because it's been going on so long. Well, the reason it's been going on so long is because it's been embroiled in litigation for so long, and then it's like it's a foregone conclusion, and I think that's frustrating from an appellate standpoint, because it feels like sometimes our hands are tied based on what's, you know, the length of time that's taken to get to us.
Sure, and I don't disagree with you. I'm not sure what the fix is. To me, it sounds like it might be a legislative or at least a rule fix on the part of the Supreme Court to, I don't know, you know, to expedite these cases even more, or to maybe, you know, there's a possibility. One option would be that you would have a direct appeal from an amenability decision, rather than waiting till the defendant goes and is convicted in adult court, right? The Nicholas case that's been appealed, not only was that juvenile transferred to adult court, then he went through a whole jury trial. So he spent even more time. So I guess like one of the fixes could be a legislative fix where in 250502, they say that amenability decisions are immediately appealable, you know, and the legislature's done that for other decisions. But I think where we are now, again, I would argue that you don't need to hold it. And I think with respect to that, as far as your decision, I agree. I think that the law is fairly clear, at least at our level. You know, obviously the Supreme Court's at a different situation where they can change their own precedent. But I think with Aleem, I think that as it stands now with the court's decision in Aleem saying that there's not a fundamental liberty interest in being tried in juvenile court, I think that kind of makes a due process argument at this level. I think that leaves it without merit. And then, you know, maybe the Supreme Court's going to change it when they look at Nicholas. But I think as it stands now, the law is pretty clear. We have clear standard for what we're supposed to do, which is to look to see if there's any rational basis for the decisions. And if I can just speak real quickly to the second assignment of error, as far as the abuse of discretion, I don't know how you could say that the juvenile court in this case abused its discretion. An 11-page decision explaining his thinking with each one. As far as the serious mental illness, he said that there was no serious mental illness, and then in the next line he lists all of his mental health diagnosis. So I don't know if maybe he was making a distinction between serious and not serious. I do know that he was concerned, and it was a concern that came up throughout the amenability hearing, that it seemed as though David overemphasized his weaknesses while downplaying his strengths. And there were some questions about some other things that he had reported having happened to him. And even those, they said some of them were suspicious because he would only mention them when he was in trouble. So I think that it makes sense that maybe the juvenile court was a little bit hesitant to at least consider that his mental health as a factor, or at least maybe it kind of lessened the impact that would have had. And that's obviously not the only factor. The court looked at the seriousness of the offense, which is something that the court can take in, or the offenses is something the court can take into account. The fact that he did this the day that he was on probation, or his probation was terminated. And the juvenile court points out whether or not he knew, either way it cuts a bit bad. If he knew that he was no longer on probation and went out and did these 4 offenses, that's not good. Or if he thought he was still on probation and went and did these 4 acts, it's not good. Dr. Rothenberg agreed that he was a serious risk of reoffending. Again,
But
there was
both experts, I mean, the juvenile court completely rejected the expert testimony that he was amenable to treatment in the juvenile system.
correct.
And so I kind of question, I guess there was an expert appointed by the court,
Yes,
and then there was a defense expert
right.
for David. And so, you know, in that respect, I question how the court can just reject both of these expert testimony that he was amenable to treatment.
Well, like this, excuse me, well, like this court said in Marshall, the court isn't bound to accept an expert's report at all. And I think that this wasn't just a case of the court, you know, kind of looking at it and throwing it aside. He went through step by step and wrote about what his problems were with the experts. And this was, you know, this hearing went on for, I think, 3 or 4 days. And when you read the transcript, there were some questions about, I think a lot of the question was about whether or not he could actually get the treatment. I know that in counsel's brief, he said that the juvenile system failed Mcbride, but the fact of the matter is he had been given treatment. He had been successfully terminated from the program, and then he went out and reoffended. And I think that it's kind of counterintuitive that you would be asking then to put him back in the system that you said failed him. Judge Krause, you asked about whether or not he's getting treatment now in DRC. If you look at, it's one of the things that Judge Williams cited as considering. It's States Exhibit 6, the DRC Sex Offender Services. So there was some document put in there about the sex offender services that he would receive in DRC. Dr. Lysang seemed to discount completely the fact that he could receive some kind of treatment. She seemed, when you read her testimony, you'll see she seemed to think there was no chance of him getting any treatment. Dr. Rothenberg talked about the treatment that he should receive. It didn't really differ a whole lot from what he had already received at the IVN. That's where he was from his first adjudication. And probation officer Brock said that wherever he went, if kept in the juvenile system, pretty much what he got at IVN was going to be the same treatment he would get if he went to the other place. I'm sorry, I forget the name of it. Maybe Clear Creek, I forget. But he'd get the same treatment. I think a lot of that kind of militates against him being able to be treated successfully in the time that they had to treat him. So unless the court has any other questions, we would just ask that the court affirm. And that's all. Thank you.
Thank you. Mr. Thompson, you have 3 minutes remaining.
The state's argument sort of brought another idea to me. The standard abuse of discretion isn't going to change based on anything that happens in any court. So if we look at what the court did and what happened at that hearing isn't going to change either. So if we use the word outweigh, apply a clear, convincing standard to that on the second standard, on the second issue for review, then factor in also the state's, the second part of the first assignment of error, that the state has the burden or should have the burden of showing that David is not amenable. The fact of the matter is they didn't put on much in the way of evidence, and they certainly didn't show, we'd argue, even by a preponderance, but certainly not by a clear and convincing, which they argue the court may have considered. Maybe we could just decide the case on that front. Did the court abuse its discretion in under either standard in listening to these experts and the evidence presented to it?
So are you suggesting we kind of take over the role as a fact finder here?
Not taking the role of the fact finder, but ultimately it has to be reviewed. You have to look at the evidence before the court and whether it abused its discretion in reaching its decision. So in a way, you have to reconsider the factors that the court was able to review and the evidence it was able to review.
But
So-
aren't you asking us to adopt the two standards that are in front of the Supreme Court that we have never adopted before?
Yes, my point was that the state kind of argued that the court did use that standard when it said the evidence was overwhelming and clear. So
Well, I think the state was essentially arguing some version of harmless error, that even if you were right, you would still lose under that standard.
and my point would essentially be the opposite, that because I'm right, and we're right under both standards, preponderance or clear and convincing. And for those reasons, we'd ask that the court reverse.
All right, thank you. You are at your time. Counsel, thank you both very much for your arguments this morning. We will take the case under submission, give you a timely opinion.
Thank you.
Thank you. And Ms. Hayden, if you will bring our next counsel into the courtroom. Good morning. Our next case on our docket is Heredia Realty versus Harvey. We have Mr. Harvey here on behalf of appellant, Mr. Bobbitt here on behalf of appellee. Mr. Harvey, of your 15 minutes to argue this morning, would you like to reserve any time?
Yes, Your Honor, 2 minutes.
All right, whenever you're ready, you may begin.
Your Honors, thanks. And thanks again for the panel taking this case. Your Honors, this is a very straightforward situation. The two appellants were served with a small claims complaint several months after it was filed in the lower court. The claim is devoid of any substance. It was devoid of any attachment, such as an account or a contract. It was simply a claim for $713, which didn't have any other support. So the two appellants live out of state and have lived out of state for years. They've established residencies in Wisconsin and Missouri. So we challenged with a motion to dismiss, which the appellees didn't respond to. The lower court nonetheless denied the motion to dismiss. We then filed objections.
How do you get around Ohio's long arm statute?
Your Honor, as the court is well aware, first of all, I don't believe let me back up. It's the obligation of the plaintiff, which of course is Heredia, to demonstrate and prove jurisdiction when jurisdiction is challenged. They didn't do that, not only in the original filings, but also no response to the motion to dismiss. But to answer the court's question directly, as the court is aware, there's a two-step process to and of course, personal jurisdiction is a very convoluted subject. As a court.
Well, let me try to simplify it, because we have a lease in the record that shows that all the appellants signed onto it that is for property in Hamilton County. So how would that not be a sufficient basis for specific personal jurisdiction?
So I'm sorry, Your Honor, let me go back real quickly to a second to the answer to the court's question a moment ago. And that is the second part of the personal jurisdiction is due process. It is fundamentally unfair. There's a whole host of Ohio cases to talk about, not just minimum contact.
Well, wait a minute. Minimum contact. So to what Judge Bergeron, I think he was really narrowing in on my question. How could a lease for property in Hamilton County ever not be minimum contact sufficient for due process?
When it's not attached to the record, Your Honor, if I recall correctly, that lease or whatever was attached to the appellate record was not in the lower court record below. And we objected.
I think it is in the record.
It was not attached. It was. I'm sorry, Your Honor. It was not attached.
I think the lease is in the record. I mean, in a small claim situation, it doesn't have to be attached to the complaint, right? But it's in the record.
Your Honor, I think it's important to establish what the record is in this situation because it was not in the record filed below. The appellee.
Well, I'm sorry. I don't want to, I mean, we have it in our appellate record because it was attached, I believe, to an affidavit that was filed before the trial court. So it is in the record.
Your Honor,
I've got a copy of it on my desk.
Your Honor, I would humbly disagree. You know, let me go back for a second procedurally. When we filed the motion to dismiss, which was not opposed by the appellee, we then filed objections. We then filed the 60B, which was also not opposed by the appellee. At that point, still, there was nothing in the record about an account or an affidavit or any type of a lease. What they did was they added it when the appeal was filed. Now, if this court believes that's an appropriate add-on to a record, then fine. I don't think it is.
So wait, you're saying that the lease was attached to an affidavit that was filed after the notice of appeal was filed?
That's correct. And that's why I'm saying, you know, and I wasn't even served with it. The only reason I even knew about this, I haven't seen this material. I objected to it because not only was it inappropriately added on without a motion to this court, but then I wasn't served on me. And this is the objection we have to the whole process. They ignored the whole lower court process. And then when we finally filed the notice of appeal from the decision to not grant the 60B is when they decided to engage in the process. Now, Your Honor, as I just said a moment ago, assuming just for the sake of argument that they established personal jurisdiction, which is the plaintiff's burden, they have not established that people out of state they met the argument of due process when these people have established jurisdiction in other states.
But that doesn't matter from basic specific jurisdiction for personal jurisdiction. If you enter into a contract for property in the location, you are subject to personal jurisdiction for suits arising out of the ownership of that parcel of land.
The suit, Your Honor, I humbly disagree with the court in the statement because I think the statement is too broad. In this situation, we're talking about a one-sentence complaint with no attachments. So it's one thing if the original complaint said, okay, lower court, we have a lease, here's the contract, here's the clause that establishes jurisdiction in the lease, we have minimum context. Then we only have the due process aspect. But again, I'm making the arguments for the appellees when really the appellees, which is the plaintiff, should have been required to make that argument below. But the lower court didn't force them to make their arguments on personal jurisdiction at all. They just went ahead and granted judgment for the plaintiff over our 60B, over our motion to dismiss that wasn't even opposed below. Your Honor,
and Mr. Harvey, just to clarify, you are one of the parties in this case as well, correct? I mean, you were on the lease. Excuse me?
I'm not on the lease, Your Honor. I believe
you were named in the complaint, though.
I don't believe.
And I saw your name on the lease.
Your name is on the lease, Mr. Harvey.
Your Honor, I believe first of all, I wasn't named in the complaint. I'm not a party to the case below. I was a guarantor, I believe, or an alternative guarantor of the lease situation.
You're listed as a lessee. I'm looking at the lease right now.
Your Honor, again, as I said a moment ago, the lease was not attached to the pleadings and materials below.
Let me. I hate to interrupt you, but what did the complaint say? Didn't it say it was a claim for rent under a lease? What did it just say? It just said you owe me money.
It just said these two people owe them, not me. Those two people, the two appellants, owe the Heredia $713 for some type of contract and or an account. That was a simple
breach
statement.
of contract.
Breach of contract or an account, I believe, is what it said. Yes, and that's the extent of the filing. So for that reason,
all right. So we take that for purposes of personal jurisdiction. Then your client said there is no personal jurisdiction under the long arm statute or under minimum contacts. But and then what?
Your Honor, I apologize again. I don't believe that the party with the burden on this situation, the plaintiff, met their obligation of establishing personal jurisdiction. But I would also say that had that plaintiff, which is not in the record, had they said, okay, specifically, here's what we're claiming is what's owed and here's what it flows from. In other words, as somebody that's sort of tangentially involved in this, I don't even know where the 713 comes from, but let's assume I did. I'm thinking, okay, what is it connected to? But it wasn't attached to the original complaint. Now I'm saying, why did you wait so long to file against people that you clearly had to sue out of state? It's not like these people were in Hamilton County when the suit was filed. These people lived out of state. So, they waited years to do this. There's statute of limitations issue as well, but that's not part of it.
But I mean, the statute of limitations is like 15 years for breach of contract. So
oral is 4, Your Honor. Thank you. Yeah, that's 4 now, I believe. But the point still is that the substantive claims and defenses were not even addressed because we didn't get to them. But the point also is that I believe that the motion to dismiss was improperly granted for the police, and also the 60B, which we then filed because the time lapsed. And that's another issue. We were getting orders from the clerk's office at 13 and 14 days. We filed a motion 60B1 and 60B2 because I said the mail was like coming weeks after. This is during COVID. And I said by affidavit, I said, listen, clerk, I've got to find a different way to do this because I'm not getting the stuff within the Rule 53 dates and times. But the court would not grant the 60B, which was not even opposed. And so, here we are. And I'll rest.
You're not really arguing that there's not personal jurisdiction. You're arguing that the plaintiff didn't establish it.
I'm arguing that they didn't establish it. Had they attempted to try to establish, they couldn't have established due process aspect of the 2-part test that the Supreme Court has said many times.
Okay, and I want to put a fine point on that. So you're saying that if the lease was in the record and showed that 2 people had signed it for property in Hamilton County, that would not confer specific personal jurisdiction over them for a suit arising out of the lease?
It would have depended upon what was in the lease and what it stated, Your Honor. It's not in the record.
It's a standard lease that says you pay this much for this property.
Well, yeah, I don't want to.
I'm sorry, but that is specific personal jurisdiction. I mean, under Supreme Court precedent, under Ohio Supreme Court precedent.
I think that even if the court were to look at it that way and realize, of course, that the appellee didn't meet their burden, there's a 2-part test, not just minimum contacts. Is it proper due process to hail people from out of state who have long gone into this jurisdiction in Hamilton County for a claim that allegedly was improperly framed and supported to begin with, which is what we've said. So it's a multifaceted argument we're raising to this court below. But it's look, I don't know what the appellee did and why they did it the way they did it. But all I'm saying to this court is that I don't believe they properly made their arguments to the lower court, and we should have been able to have this case dismissed. Thank you, Your Honors. I rest.
Bobbitt, you've got 15 minutes.
Thank you. My name is Scott Bobbitt. I'm here on behalf of Heredia Realty. First and foremost, since no transcripts of the hearings are on the record, this court should assume everything was done correctly. As to whether or not a lease was attached under ORC 1925, which governs small claims, all that's required is a general pleading requirements that includes residence of the parties, military status, and the nature and amount of the claims. Civil Rule 10D doesn't apply in small claims, so we weren't required to attach a contract.
So help us out. When was the lease filed into the record?
It was attached to the affidavit presented at the hearing.
Affidavit of whom? I'm sorry.
I believe that would have been Tracy Snyder, but the affidavit that we presented at the hearing that the opposing counsel didn't show up for, where we got default judgment.
So before the motion to dismiss based on jurisdictional grounds was ruled on, or after?
That motion was dealt with at the hearing. I believe the motion was filed first, and then we showed up to the hearing, dealt with the motion to dismiss, and then presented the affidavit once it was over.
So did the court in essence set an evidentiary hearing on the personal jurisdiction issue? Is that what you're saying? And you presented evidence and that the other side didn't show up?
That's correct. When we presented the lease that dealt with property in Hamilton County, the magistrate just overruled the motion to dismiss.
So was that actually a trial?
It would have been a default hearing.
Okay.
It would have been set for a trial, but it would have ended up being a default because they didn't show up. The appellant claims that he could not, it wasn't possible for him to file his objections on time, but he could have faxed it, he could have e-filed it. He had numerous options to do so, and he just didn't do so. And as to the Rule 60B motion, he relies heavily on Mid-America Acceptance Company versus Lytle. But in that case, the attorney had showed up on 4 different occasions, whereas on this one, he failed to appear at a single hearing, so it shouldn't constitute excusable neglect. And he also doesn't have a meritorious defense. We've already established that personal jurisdiction was established and that no contract was required. So the Rule 60B motion was properly denied. And that's all I have.
And Mr. Harvey, you will have 4 minutes left because you did not use all of your time. But let me start off asking you a question kind of before you left off. Sure. Assuming that the complaint is for a breach of contract, that contract being a lease for residential property, is it your position that somebody could come into Ohio, rent an apartment for a year, and now I'm assuming a fact that wasn't determined because it was a default judgment in essence, but assume that the person renting the property left the state of Ohio owing the landlord money and left the state, moved somewhere else. Is it your position that it would be fundamentally unfair under the minimum contacts to hail that person back into an Ohio court?
The short answer,
I think that's what you're saying.
I think that's the short answer, Your Honor. That is exactly right. I mean, the fundamental issue to your question is a company like this making a baseless, generalized statement because they don't have to add whatever they don't have to add because of the rules you just heard.
What's the baseless statement you're talking about?
Well, that they're owed $713 for something, but they don't specify how or what, and they don't attach anything, and they never make a record as to what it is that it's based on. I mean,
well, let me ask you this then. Is he wrong when he says this was set for a hearing to determine the an evidentiary hearing to determine personal jurisdiction? His client came with evidence and your client didn't show up?
Your Honor, he's absolutely wrong. It's the first time I've ever heard today of any transcripts. It's the alleged transcript. There's no transcript. This was during COVID, so there was no hearings going on anyway. And this is the first time I've heard of any hearings. And I'd offer this court to ask the appellee to prove by the docket, which is locked. I couldn't get to it yesterday, what hearings there were, what transcripts there were, because there wasn't any. And of course,
so if the docket shows that there was a hearing on the date that the affidavit was filed, what do we do with that?
Well, if that docket shows that there was a hearing and that there's a default judgment against us for not appearing, that's one thing that we're not even aware of, Your Honor. As I sit here talking to this court, I'm not aware of any default judgment. But I am aware of the fact, though, that none of the things that my opponent just mentioned were sent to us. For example, the so-called affidavit with the lease, we don't have. There's no opposition to the motion to dismiss or the 60B by the appellees. And as I said before, they knew that we were contesting this. So you'd think at least at some point they would properly support the record with whatever materials.
Well, maybe they were planning to do that at the hearing, and your side didn't show up. So what's wrong with them substantiating all that at the hearing?
Your Honor, I would even beg to I looked at the appellee's brief, of course, and I don't see any reference to a hearing or any hearing materials filed.
The docket shows that there were hearings set in this case.
They were They were non. You know what, Your Honor, if there's any hearing set, it's because it was the way they said it was they'd have a hearing to look at the papers that were filed before it, not an evidentiary oral hearing where the party showed up on Zoom to have a record. That they were having non-evidentiary, non-oral hearing is what that
So
was.
you're saying there's no transcripts available
That's correct.
of any hearing below?
There was no transcript taken. That's why there's none available. And so going back to what I was saying earlier, Your Honors, first of all, I believe we've established that the appellee did not establish jurisdiction. And second, that they didn't, that the lower court made an error, maybe an abuse of discretion standard error in not granting the 60B1 and 60B2 because we objected timely. We had a legitimate basis to object and the court just denied it without even opposition by the appellee. So I think, I'm sorry, Your Honors, I apologize. This is the first I've ever heard of hearings that the appellees allegedly showed up for. I'd like to know who was there allegedly. But I know one thing, it wasn't me and I got no notice of anything. We would have been absolutely involved in that hearing had there been one set. And I'm very distressed to hear that today. But more importantly, Your Honor, to go back to jurisdiction, in my humble experience, you can't, if you wait as long as they waited to bring these claims and small claims for reasons I still don't know, you've got to understand people move around and then to try to hail.
But I'm sorry, that's just not the accurate due process analysis. You look at whether there was specific jurisdiction arising out of the acts that are complained of, and the fact that someone moves around doesn't matter. What matters is what was their connection with Hamilton County at the time.
So I would say, Your Honor, bringing a baseless, unsupported allegation of being owed money, which anybody could do apparently, and that would be jurisdiction over anyone in the United States, it would be, with all due respect, a ludicrous extension of that argument. You cannot ignore the fact that people out of state should not be hailed into Ohio on an unsubstantiated claim like this, Your Honor.
But they substantiated. They brought the lease.
I don't believe it's on the record, Your Honor. Thank you. I'm sorry. I disagree. I think they did it. They didn't do it appropriately, and I still don't have copies of it. I said that you'll see in my reply brief. I said we didn't get any of the materials that they allegedly put in during the appellate process, Your Honor.
They're part of this. It's part of this record, though. I mean, you need to understand that we all have read and seen copies of the lease, and it's part of our record.
And I don't have it. It was not served on me at any point. Just like I didn't get copies of any oppositions to the motion to dismiss or the 60B motion or any motion for default that allegedly filed by them.
Did you fill out the required paperwork with the court to get notice?
I was getting orders from the court, Your Honor. So apparently I was of record. Sure, I've got all the court orders. I just don't have any information suggesting there's a default issued because I missed a hearing. This is the first I'm hearing this today. So,
well, what's your understanding of, and we are at your time, but I do want to ask you this. If you're unaware of a default judgment, what's your understanding of what the final judgment was in this case? After trial? On a motion for summary judgment? I mean, there has to be a judgment.
I'm not certain exactly how to answer that question. I would imagine that I think from what I could see, the court granted the 60B because I didn't file objections on time. The court denied the 60B, I'm sorry, and granted judgment for the appellees for the 713, I believe, is what ended up happening.
I'm sorry, I know we're at your time, but like the entry that you've attached to your appellate brief says motion to dismiss denied, trial will be held on 3/12/21. So how did you not have notice of that hearing if you attach this to your brief?
Your Honor, if the court looks at the docket, I don't think there was any trial held on 3/21/21 that I'm aware of.
Okay.
Thank you, Your Honors.
Thank you.
All right. Thank you both for your arguments today. We will take this case under advisement and give you a timely opinion. Ms. Hayden, if you will bring the next counsel into our courtroom, please. Good morning. The next case on our docket this morning is In Re AK. And I don't know if everybody else's screen is the same, but can everybody see each other?
Yes.
Did I just change it? If you can change it to gallery view up in the upper right hand.
There we go. Thank you. I think Judge Bergeron changed it maybe for all of us, or someone did. Thank you for that clarification. Our next case, as I mentioned, is In Re AK. Ms. Moss is here on behalf of appellant. Ms. Steer is here on behalf of appellee. Ms. Moss, would you like to reserve any of your 15 minutes today?
Yes, Your Honor. I'd like to reserve 3 minutes.
All right. Whenever you're ready, you may begin.
Good morning, Your Honors. Ms. Steer, may it please the court. My name is Jessica Moss, and I represent the appellant, AK, in this matter. This case concerns a bottle of pills, of oxycodone pills, which were found in AK's purse. As to the first assignment of error, the juvenile court erred in allowing improper statements and evidence to be introduced at trial. And within that, there's 2 issues. The first are these statements by an unidentified person who did not testify at trial. And
so on those statements, there was a hearsay objection to them coming in, but there was no confrontation clause objection that I saw anywhere in the transcript. So my question is, was the confrontation clause aspect of that preserved?
At the trial, only hearsay was objected to. However, on objections, the confrontation clause was raised. And so since Juvenile Rule 40 does allow additional evidence and information to be introduced, we would argue that that was also raised at that point. But the hearsay and confrontation clause do go hand in hand because it starts off as being a hearsay issue because of the statement where a person wasn't there to testify, and it's going really to the truth of the matter asserted, because here the state used the statement of this allegation that AK was allegedly selling Xanax, which was not the drug that was found in AK's purse, as essentially proof for them that AK knew that oxycodone was found in AK's purse, and that's what the state indicated at the trial.
Well, but see, I'm sorry, go ahead, Judge Myers.
No, you go ahead, Judge Bergeron.
Well, but my concern about that, though, is what you're relying on are questions by the prosecutor, which is different than testimony by a witness. And it seems to me that the prosecutor strayed pretty far afield from the actual statements, which may be misconduct and maybe it was improper, but that's different than a confrontation clause violation.
And I understand, Your Honor, again, our argument was that the 2 really went hand in hand together with this, and, with the statements of, accusing AK of shaking the pills, and that's why somebody allegedly made the statement. But, this wasn't a statement made just to explain the school's decision to search AK's purse, to explain the next steps. It went further, and they were using this as to be truthful when that was not appropriate in this situation to allow the statement for that purpose.
If we agree with you that it was inadmissible hearsay, we don't even get to the confrontation clause, do we?
Correct.
And then we would have to look to see whether or not it was harmless error to admit it. Would you agree with that?
Yes, Your Honor.
All right.
And with that, because of this is not a case where there was substantial evidence, a lot of it comes down to a credibility determination. And I'll talk about it as part of the other assignments of error as well, but you have statements of AK's grandfather saying that these are his. You have other items of AK's grandfather in the purse as well.
Well, let me ask you about those other items, because were the other items revealed in the photograph of the contents of her purse?
They were not, Your Honor. And that's one of the problems we have as to the second part of the first assignment of error, is that you have State's Exhibit 1, page 1, which has some of these items, not all of the items, which include these other things of the vape pen, rolling papers, and a lighter, which is what we have an issue with, because it's not showing these other items that really would have been relevant of the grandfather's wallet, glasses, keys. And then
the last question I'll ask you about the purse is the bottle of pills, as I understand it, does not have any indication that it is actually the grandfather's pills. And I just feel like from a harmless error standpoint, that undermines the claim, because if he had put that in, I think we would presume they would have like his name and information on it, but that's not on there.
I don't believe that was on there. And I believe that there was a case a while back that talked about not having to have, somebody's actual name on a prescription bottle. He did call the officer the day after and say, these are my pills, and you have these other items of his which were in the purse. But, if those would have been relevant, if the issue is, the state saying, AK would have known they're in her purse because you would have seen them, then seeing what all would have been in the purse to see what could have been covering up this bottle. But just because there wasn't a name on the bottle itself that it was the grandfather's doesn't mean that his call to the police officers and AK not realizing that they were in there, that was inaccurate, or that shouldn't have been believed.
So on the harmless error analysis, I mean, we have a situation where the magistrate judge tells us exactly why she disbelieved your client. And I think that the reason it was your client gave several different responses to why those pills were in her purse, including one response, I guess, right when she was questioned, that she got the pills off the street from somebody. And so, the magistrate judge does not rely on this tip that was discussed by one of the witnesses at all. And so I just question, it seems to me that there's sufficient evidence here, and it didn't really affect the tip information, which I know that prosecution relied heavily on, didn't really affect her decision.
Yeah, and that really goes into the third assignment of error in terms of the manifest weight of the evidence, and the statements that came in about AK allegedly changing her story all came in from this Officer Dye, but it's really Officer Dye's testimony, which was all over the place, not AK changing her story. Miss Terrell, who was the school, the student security student monitor, was the one who was there during, before the purse was searched, during and after. And her testimony was that the only statement about the origin of the pills was that AK said they came from AK's dad or someone at the house, which is consistent with AK then once knowing what the pills were, that they were oxycodone, saying, those must have come from my grandfather. I took him to the doctor the day before and he put them in my purse and I didn't know that they were in there. Ms. Terrell never talked about or testified to the fact of any statement by AK saying that she got them from somebody on the street or from a dealer or anything like that. And so it wasn't as if you have that corroborating Officer Dye's testimony. Really, Ms. Terrell's testimony with the items in the bag, as well as AK's statements, all corroborate each other. It's Officer Dye's that really is the outlier here. So in looking at the credibility and what the court looked at, that determination in the harmless error issue doesn't make sense when you consider where that statement came from and that other evidence. And just like a number of these other cases where you have photographs, when the state had other photographs and evidence that they could have used, the photographs themselves with these other items certainly weren't necessary. The state had the actual bottle of pills and the pills themselves, as well as a photograph of the pills by themselves and the bottle by themselves. There was no need to introduce the first page 1 of State's Exhibit 1 with these other items, other than to show some improper character that was improper for the court to consider.
So are you saying that the evidence of vaping is sufficiently improper character to impinge on the fairness of the trial?
I'm saying that the evidence of vaping has no, there's no connection to that of having oxycodone pills. You're not, vaping oxycodone pills. So one doesn't have a correlation to the other. And, even if.
But then that's my question. Well, then why is it harmful to the defendant that it's admitted?
because it essentially the state's saying, you know, if AK has these other items, then clearly AK would have had these pills and known these pills were in her purse.
I mean, I'm not sure that follows because, I mean, you could probably go into any high school in the country and find a substantial percentage of kids with vaping or cigarettes or something like that. And I don't think that that necessarily correlates to using illegal drugs.
Our concern is that it does have the correlation or the potential for that correlation, but with how the state was essentially saying that they were using these statements, not only by this unidentified person, but all of this to show, you know, that they believe that AK knew that these pills were in her purse. If those other items were introduced, they still have these photographs of the pills themselves and the bottle themselves. So if it wasn't to try to make this correlation, there would have been no need for the state to try to put that in. It could only have been for some other purpose, which would be an improper purpose. As to the second assignment of error, this is essentially unwitting and unknowing possession of these items. And we have a situation if somebody doesn't know items are put in a purse or on property, you know, not only would AK have to have the ability to take dominion or control over the items, but has to know that they were there. And when you consider, you know, that there were these other items of AK's grandfather also in the purse in a large tote bag, it is certainly reasonable that AK wouldn't have known they were there when she took her grandfather to the doctor the day before and hadn't looked back into her purse before going to school just the next day.
So the evidence of the other items from the grandfather came in solely through AK's testimony?
Yes.
Okay.
And
which the magistrate discredited as not credible.
The magistrate only discredited her statement of where the bottle about the actual pills themselves. There was no statement about the other items of the grandfathers, such as the glasses, wallet.
Was there any cross-examination of whoever took the photograph as to why it might have been under-inclusive of the items?
There was no questioning about that. You know, really, Officer Dye's questioning, you know, at one point he's saying AK knew the pills were there, and then even when the state then asked him for the question, how did AK know? Then the officer statement changed again. Well, she didn't know, she didn't deny it, or she did deny it, but she didn't say that she knew. It was all over the board. And, you know, he went through a series of those kind of changes of what his testimony was.
And you are at your time if you'd like to reserve 3.
Yes, sir. I will reserve the remainder of my time. Thank you.
All right. Ms. Steer?
Good morning, Your Honor. It's Ms. Moss. May it please the court. If I can just start off with the statements to Ms. Terrell about someone selling, I forget what they were supposedly selling, Xanax, I think. I think that just explained, when she first talked about it, the prosecutor actually stopped her from saying someone said something, and she said, so I went and got AK and brought her in to do a search. Even if those statements were inadmissible, they're harmless in light of the fact that.
But I guess like the juxtaposition of what you said about like the prosecutor stopping her, like in recognition that this is hearsay evidence and need to be, you know, tread carefully upon. Just when you look at how he cross-examines her and just uses that as substantive evidence, essentially, and repeatedly, I mean, frankly, badgers her about this, repeatedly asking the same question over and over again, it just seems to be an improper use of either evidence outside of the record or a mischaracterization of the testimony.
I think, I mean, obviously they weren't coming in as evidence. There were his questions. Whether or not those were improper, that hasn't been assigned as error. But even if they were improper, the magistrate was capable of separating out the relevant information and what wasn't hearsay. And she said she like specifically listed what she was considering. And that did not, as Judge Krause said, that did not go into her consideration. I think the biggest factor for the magistrate, and rightly so, was that she didn't believe AK. AK first said, as far as what was in the picture of the pill bottle and then the vape pen, I think that the reason why those were all together was there was a separate charge for drug paraphernalia to which AK pled commit before the proceedings started. And I think that was the vape, whatever vape pen thing, I don't know what they're called. I think that was the basis of the paraphernalia, which is probably why it was in a picture, because I think until the day of the hearing, the state didn't know that she was going to admit. So that's probably why they were in there. The magistrate was clear that she was only going to pay attention to the stuff that was relevant to the charges that were in front of her. When on page 50 of the transcript, when AK is being examined, at first she says, they ask her, is that everything? Did they show you everything they found, and was everything yours? And she said, yes, except for the oxycodone. It's later on that all of a sudden she's talking about her grandfather's wallet, keys, and other things being in her purse. That's the only evidence. Her statement is the only evidence that there was something else in her purse connecting it to the grandfather. And even if, as you noted, Judge Bergeron, there was nothing on there that had his, I think it was you, that had his name on it. Even if it did have his name, it wouldn't explain why she had his pills. It would have made it slightly more believable. But in light of the other statements that she made, when first she said she told Officer Dye she got them off the street and she knew they were hers. That's her first response. And then she told, actually it was her second response, because she told the school resource monitor that they came from her dad or someone in the house. So that was her first story. The second story was she got them off the street, but she wouldn't say the person's name from whom she got them. And then she said, and I'm not even sure if she said it when she was being arrested, she said they were her grandfather's. Her grandfather, I think, came to pick her up when she was arrested. And it was only the next day that he called Officer Fox and said that Officer Dye, excuse me, and said that those were his. And Officer Dye obviously didn't believe him. So I think in light of all of the evidence, I mean, the pills were in her purse that she had next to her. People know what's in their purses. I know she said that it was a big tote. That's not really, and she asks the magistrate, do you know what a Michael Kors tote is? I don't know what that is. I'm assuming it's a bigger purse, but still she would know what was inside there. And she said that everything in the purse was hers. So I think in light of the credibility determination that was for the magistrate to make.
Do you believe that she properly preserved a confrontation clause by raising it in the objections to the judge?
I think that it would have had to have been made during the hearing.
So you think this is a plain error review for us?
Yes, it would be plain error.
But if it's hearsay, and if it was improperly admitted as hearsay, then it's a harmless error review.
Correct. And I just don't think that, I think really in light of the fact that clearly the drugs were in her purse, and the fact that the magistrate just did not believe the stories that she was telling, I think that any error in allowing those statements about why in the first place they brought her in to search her would be harmless. So the state would ask that you affirm the adjudication. Thank you.
Thank you. Ms. Moss, you have 3 minutes remaining.
Thank you. Here, the court made a determination not only did they didn't believe AK, but they didn't believe AK's grandfather of the statement from his phone call the day after AK was released. However, the court upheld the statement as being a statement against interest at the time of the trial, which means that that statement was inherently credible and reliable. And if the court wouldn't have found that to be reliable, the court wouldn't have upheld that statement or admitted it as a statement against interest. And so that's, in looking at the manifest weight of the evidence here, goes to show why this decision by the court was so unreasonable and arbitrary when they had admitted this as a statement against interest.
Well, just because the court allows that statement in, doesn't, I mean, yeah, it might have been a statement against the grandfather's interest, but also the court could disbelieve it, believing that the grandfather was simply trying to protect his granddaughter. It doesn't necessarily mean that the court thought it was a true statement, right?
Well, a statement against interest is inherently reliable. So if it's going to be admitted, it's only inherently reliable. So if the court didn't find it to be reliable, then the court wouldn't have admitted it as a statement against interest. And so when you take that information combined with the fact that Ms. Terrell didn't back up any of the statements allegedly made by AK that Officer Dye testified to about getting these pills off the street, it's clear that all of this NAK statements should have been believed by the court with these other items. And as to, I think it's Judge Bergeron's question about the glasses and the wallet and those other items, I think some of the testimony may have been a little bit unclear as to asking what was in maybe the photo. If she was saying, yeah, the only thing that wasn't in there was a pill bottle, and that being clarified later on redirect examination as to these other items that were the grandfather's. But the state didn't present any evidence to refute that there were other items in the purse which were not presented or pictured in that State's Exhibit 1, page 1. For all of these reasons, we would ask that this court reverse the juvenile court's adjudication. Thank you.
Thank you. Counsel, thank you both very much for your arguments this morning. We'll take the case under submission and give you a timely decision.
Thank you.
Thank you. Have a good day.
Thank you. You too. Ms. Hayden, if you will bring the next group and Judge Winkler into the courtroom, and I will exit. For all of these. Both very much for your arguments this morning. We'll take the case under submission and give you a timely decision.
Thank you.
Thank you.
All right, good morning, gentlemen. Welcome to the First District Court of Appeals. The last case for argument today is State Ex-Rel Michael Rimroth versus City of Harrison. Mr. Lewis, you're for the appellant. How much time would you like for rebuttal?
I'd like to reserve 5 minutes, Judge, for rebuttal, please.
Okay, very well. You may proceed when you're ready.
All right, Judge, on behalf of Mr. Rimroth, primarily the case was resolved not on merits and not on presentation of evidence or trial, but my client's claims on the merits, Rimroth's claims on the merits were never reached. They were never adjudicated. Also, Rimroth's claims that Kugler, the other candidate, was not eligible, those were never adjudicated either. The court, by entry dated March 10th, 2021, entered an order finding the motion that the City of Harrison had filed to vacate the briefing schedule moot, and then just basically sua sponte, dismissing the case.
Well, let me ask you about that, Mr. Lewis, because the crux of what you're saying is basically a due process violation, that the court went and took some action that without giving you notice. But there was a hearing, and we don't have the transcript from what happened at the hearing that could have, conceivably addressed any sort of due process issues. So what are we to do with the fact that we don't have the transcript from that hearing? It's not in the record.
Judge, are you talking about the hearing? I'm not clear on what hearing you're talking about. I had filed a motion for a preliminary injunction and a temporary restraining order. That was filed, and along with an affidavit, that was filed on the 23rd of September 2020. Now, the trial court, the very next day, denied that motion. It was actually the trial judge on the 23rd, if you look at the entry, has an indication there of entered September 23rd and then again entered September 24th. So
Well, I believe the hearing was on March 4th, 2021. So that was after the motion to vacate the briefing schedule and your memo went off.
Right. And then on March 10th, the order went on finding the motion to vacate the briefing schedule moot. The problem I have with that is there was never a briefing schedule filed. There is no briefing schedule in the record. And we had orally discussed filing a motion for summary judgment, but there was never an entry fixing that date. This was just an oral discussion with the court.
What are you saying was still pending? This court remanded the case to the Civil Service Commission.
Right.
So what was still pending in the trial court?
My client's claims were still pending in the trial court. They had never been resolved.
Which claims?
We had a declaratory judgment claim asserting that we had the right to promotion, Rimroth, and we also alleged statutory claims, the right to promotion, and we alleged that Kugler was not eligible for promotion.
But that was litigated on the first appeal, right? And this court disagreed with that and said that they were both eligible and that it needed to be remanded to the Civil Service Commission.
No, Judge, I don't believe on the first appeal that particular issue was ever litigated. The closest
it was raised, though, correct?
It was raised by me, certainly, but it was not litigated. I don't believe it was litigated, and I don't want to say something wrong, but I don't believe it was. The issue was raised when I filed a motion for preliminary injunction and temporary restraining order, specifically on that issue. But those presented different issues. The preliminary injunction and the temporary restraining order, the court entered a one-page, this was on September 24th, 2020. The court, and again, this was one day after I had filed my TRO and the affidavit and preliminary injunction. There's a one-page order entered on September 24th saying the court finds there is not good cause to grant the motion. The motion is denied. So the court is ruling on a separate issue. I believe it does not reach the merits of whether or not Kugler was eligible. The court ruled that we weren't entitled to a preliminary injunction or a permanent injunction. The court could have been, and we don't know because the court didn't put its factual findings in the record. The court could have been thinking we couldn't show irreparable harm at that point for a preliminary injunction. The court could have been showing that we hadn't proven that Rimroth was likely to prevail on the merits. I'm just saying those are different standards than the specific legal issue of whether or not Kugler was eligible. And on these promotional eligible lists, I'm sure the court is well aware, they're only good for a certain period of time. I believe this one was 2 years. But once, if the list expires, the whole idea is if the list expires before someone's been promoted, then they don't get that promotion. What we did, what Rimroth did.
Mr. Lewis, let me ask you a question. I'm looking at the conclusion from the first appeal of this case where this court specifically directs that the cities of Harrison, Rimroth, and Kugler will be the candidates for that promotion.
Right.
So you're saying it, but we've already decided that, haven't we?
I don't think you've decided, Judge. It said the conclusion of the opinion on February 5th at page 9 said the candidates should proceed through the remainder of the selection process.
So they did that, And then there wasn't a subsequent administrative appeal after the conclusion of that, right?
No, I didn't file a separate appeal. No, I mean, we had already objected throughout the case. I had, as I indicated before, I know that we made an objection when the case was on appeal the first time, and when it was before the trial court the first time as to Kugler's eligibility. And then the second time it was raised also. So the issue was there, but it was never specifically addressed by the court. We don't have factual findings. We don't have, and my client never got to the point where he was able to present his case on the merits, because what the judge did was the judge on this motion, what the court is calling motion to vacate briefing schedule, there was no such motion. There is no motion in the record. We talked verbally about.
Well, the judge found that he didn't have subject matter jurisdiction over this case, right? Like he realized there was nothing left for him to do, and that's why he dismissed it.
Well, I don't think he did discuss subject matter jurisdiction, but the basis of the finding was that the issues were moot because Kugler had been, the administrative process did go on. Kugler had been promoted, but as I say, that to me, that doesn't end the inquiry because we haven't been allowed to raise specifically Kugler's eligibility.
So we keep asking this question, but that was something that was before this court on the first appeal. And I believe that you argued that Rimroff was the only one who was eligible. And this court rejected that argument and said they both were and remanded it. I mean, wasn't that already determined?
I don't think that particular point was determined, Judge. I agree with you that the court said that both candidates should proceed with the administrative process, that while the civil service, specifically what the court held was that the Civil Service Commission should recalculate seniority points, correctly calculate those, and then the rest of the administrative process should proceed. But I know I keep saying the same thing, but I just don't think you'll find in the record a specific finding that Kugler was eligible, because as a matter of law, he just wasn't. And there was no motion to dismiss. I guess a bigger issue here is the way this came about, because we never had a chance to respond.
Mr. Lewis, sorry to interrupt you, but you are at your time if you'd like to reserve 5 minutes.
Yes, I would. Thank you, Judge.
Okay, thank you. Mr. Dieters. You're on mute.
I'm sorry, I knew I was going to do that. Bill Dieters on behalf of the city of Harrison, and I'm also the law director at Harrison, Your Honor. And I have to say that I'm having a little bit of a hard time following why we're even still here. I think Judge Krause and Judge Bergenhoff, you mentioned, first of all, this case went before you already on the Ohio First District Court of Appeals, and there was a couple different claims that were made in it. One, that Mr. Lewis argued that Mr. Rimroth was entitled to the position under mandamus, and this court indicated that they did not believe he was. And what's important, I think, is what Mr. Lewis is failing to mention is that there was a trial, a factual evidentiary hearing on this issue in the court when it was first litigated. And the issues regarding Mr. Kugler and whether or not he was considered for this position in relation to Mr. Rimroth were put into evidence. And I believe if you look at your opinion from 2020, you indicate that at best, Mr. Rimroth is entitled to be considered for the position, but he's not entitled to the position. I also think there's a real question here. You know, when this was remanded back to the Civil Service Commission acted appropriately recalculated the scores, indicated that Mr. Rimroth and Mr. Kugler were eligible now to be considered for the second phase of the process, which is interviews at the city. At that time, Mr. Rimroth filed the preliminary injunction and temporary restraining order. We initially came to the court, myself and my partner Ryan LaFlame, with some confusion, because we were like, well, why is this still even in the court? Because it was remanded to the civil service. Does the court still have any jurisdiction over this case as a trial court? The trial court denied the temporary restraining order. And then at that point was still wanting, Mr. Lewis asked for a summary judgment briefing schedule. In the meantime, we went ahead with the interview process. The city actually, not that it's completely irrelevant to the case, but brought in independent interviewers in order to ensure that there was no bias or no retaliation in the process. Once all that happened, we just went back to the court and said, court, this doesn't seem to make any sense to us, because the trial court remanded it. We picked a new person for this captain position. And as one of the judges indicated, there was no administrative appeal filed. So it's almost as if, in our opinion, once the appellate court opinion came down and we followed those requirements as set forth, that particular case at that point was over. The issue whether or not Rimroth was entitled to mandamus to get the position, the issue whether he was entitled to back pay, all of those things had been decided. And the court went further to say that this is how they wanted this to proceed: recalculation of the scores and Rimroth and Kugler to go through the process, the selection process. So, sometimes I'm having, just this entire time we've been in this appeal process, I think we've been having a hard time following, like, what is the assignment of error and where we really are on the case. So I don't need to waste any more of the court's time related to that. Our position is that the trial court didn't even have jurisdiction on the case after you rendered your decision. The city followed that recommendation and requirement, not recommendation, that order. They chose to promote Officer Kugler, and there was no administrative appeal filed. If there was something happened in that process after you remanded to the civil service, that's a separate issue that is not in the first.
So your position is, if they had wanted, if Rimroth had wanted to continue to challenge this matter after that decision, the remedy would have been through a new administrative appeal.
Yes, Judge, that's what I think, because it would have to have been a new assignment of error or something new that they believed was not done correctly.
Right. Like the process is tainted again or something.
Correct. Like that. Yeah. And I think that, there's a lot more I'd like to say. It's in our brief. I don't necessarily need to waste the court's time in this process, but that's essentially where we are. And I understand that there's this desire to have Mr. Rimroth be appointed, but I don't know how the court could not have addressed it more clearly in the mandamus not being appropriate and that he not be entitled to that position. So if there's some other reason beyond what was litigated in the first case, I believe that would have had to have been something that came up in the selection process after the court's opinion. And there was no appeal filed to that. So I think that it's not properly before the court. Thank you.
Okay, thank you, Mr. Dieters. And Mr. Lewis, you have 5 minutes.
Thank you, Judge. Well, as I read I don't think the matter was over after the Civil Service Commission recalculated seniority. The conclusion in this court's February 5th, 2020 opinion said that the candidates should proceed through the remainder of the selection process. So
what didn't happen? What didn't happen there? I mean, they went through the process and the city picked Kugler. Like, how is that not the completion of the selection process?
It is. It's a flawed selection process, though, because Kugler was not eligible.
Well, but then if you're right that it was a flawed selection process, isn't your remedy to then challenge that administratively?
Well, I don't know how many, and I'm not trying to be flip here, Judge, but I don't know how many times we have to say that Kugler wasn't eligible. I believe we raised it in the first appeal. It was certainly mentioned in our motions briefs, and then in the second round after remand, we raised the issue many times, and he's either eligible or he's not.
So so you're saying you raised it in the first appeal. Are you saying that this court missed the argument and just didn't address it?
I think that's correct, Judge. I don't think it was specifically addressed.
Did you file a motion to reconsider,
No, I didn't.
explaining that we missed one of your issues?
No, I didn't. But I'm positive that on this appeal, it was raised a number of times. I specifically filed a motion to preserve Rimross eligibility. Kugler never did. And that's the primary problem, I think, in addition to the fact that I think there's as we started out initially talking about, I think there's a procedural due process problem here because the city had never requested dismissal. There was no motion to dismiss. No dispositive motion was filed by either side. So I believe that the trial court, in ruling on a motion that was non-existent, motion to vacate this or ruling on a document or a filing that never existed, sua sponte dismissed Rimross claims.
Were you at the March 4th, 2021 hearing?
I'm sure I was.
Okay, and why didn't you file a transcript of it so that we could see what happened?
I can't recall, Judge. I mean, I can always go back and do that.
I mean, it's problematic because we don't know what was argued at that hearing. And don't we have to presume regularity of the proceedings? I mean, you're saying you didn't get a chance to argue against dismissal, but.
Well, it's because the dismissal came about on the motion to vacate briefing schedule, and there is no such. So I responded to that motion to vacate the briefing schedule, but then the court, in ruling on that, didn't vacate a briefing schedule. The court granted relief on its own that the city had not requested. They never requested a dismissal, and the court sua sponte dismissed it.
I thought the city said there was no pending dispute between the parties for the court to decide.
Well, they may have said that, but I don't agree with that. I think the filings throughout this case after remand demonstrate there is a pending dispute, and there always has been. Reference Mr. Kugler.
Okay, thank you, Mr. Lewis. Thank you both, gentlemen, for your arguments this morning. We appreciate it. The case will be taken under submission, and we will issue a timely written decision.
All right, thank you very much.
Thank
Hope
you,
you both have a great day. Take care.
Thank you.
Okay.